but you did get in the vehicle knowing you were intoxicated with your 9-year-old son, and you ended up killing someone.
When this defendant caused a fatal crash while driving intoxicated with his 9-year-old son in the car, the judge made it clear he would not be walking free.
Clause numbers 25 DCCR 0386 and 0387 entered pleas of guilty to intoxication, manslaughter, as well as driving while intoxicated with a child less than 15 years old.
Initially, when I made scene, I was expecting, like I was dispatched to two vehicles. Then I later found out the two vehicles that I rode up on, one was the deceased's vehicle, and the other one was the witness that witnessed the entire crash. I didn't see a third, but I couldn't really comprehend what had happened because I couldn't find the car that did everything. And then I later found out through on-scene personnel that the vehicle that caused the crash was further down the road, upside down.
Was the vehicle that the defendant, Ray Anthony Noe, was out driving, did it have any passengers in it?
It did. It was his child. I think he told me at the scene here that he told me he was 9 years old.
Through your investigation, did you determine if that child was restrained in that vehicle during the crash?
The investigation determined the child was not restrained at the time.
You'd already informed him that someone had died as a result of that accident, correct?
I did.
Before you informed him, and even after, did he ask or inquire of you what happened to the other individual or individuals involved in the accident?
Everything on that night, he, from what I can recall and remember, everything he mentioned or asked, none of it was about the other parties. It was all either about himself or his son.
I just wanted to apologize, ma'am.
I mean, if you want to testify, you can get up on the stand because you'll be subject to cross-examination. So you can't just make a statement to me. If you want to get up on the stand, I'll swear you in and then the attorneys can question you.
No, Your Honor.
Okay.
I'm not sure that any of the evidence produced by the state, particularly on the scale of belligerent and reckless defendants, actually rises to that level, and nor is his decision to exercise constitutional rights belligerent or reckless. And for these reasons, we ask the court to consider or not consider the statements regarding belligerent, or at least consider the evidence that was presented for what it was. And otherwise, our arguments have been in our written motion, Your Honor, and we've presented information to the court, including the letter from his mother, the letters of support, and the information about his sobriety since the accident. And for these reasons, we ask that this court put the defendant on probation.
You know, Mr. Noe, these are some extremely difficult cases when someone loses their life because of your actions. Obviously, you didn't get in a vehicle with the intention to kill someone that night, but you did get in the vehicle knowing you were intoxicated with your 9-year-old son, and you ended up killing someone. You obviously had some issues, went through a treatment, a serious treatment program where you're in custody in treatment. So you have felt what it's been like to be in custody and still committed this offense. I don't think probation is appropriate in this case. Find sufficient evidence to find you guilty, and at this time find you guilty of intoxication, manslaughter with a vehicle. I'm going to sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections.